All right, let's jump in. So great to see everybody's smiling virtual faces in the participants room. Welcome to Navigating the Legal Side for the return of live events, featuring Barbara Dunn and Lisa Sommer Devlin. Let's jump into today's presentation. Okay, so what we're going to talk about today is three main topics. First, we're going to talk about moving forward, if there's any new changes or steps to introduce to your contracting process. After that, we're going to go over different kind of contract commitments to handle with your hotel partner as we fade out of the pandemic. And then lastly, we're going to go into a Q&A for all of the questions that were submitted in advance of the webinar. But before we jump into the content, let's introduce ourselves. My name is Sean. I'm the co-founder and CEO of HopSkip. HopSkip, for those who are not familiar, is a platform for planners to use to source meeting space and room blocks from hotels. So planners use HopSkip to save time and save headaches while sourcing their room blocks and meeting space for their organization, while staying in complete control of the end-to-end process. I'm going to pass it over to Barbara Dunn to introduce herself.
Thanks, Sean. Good day, everyone. I hope you and your families are safe and well. I'm Barbara Dunn. I'm a partner with Barnes & Thornburg in our Chicago office. I have the pleasure of working with all types of nonprofit corporations in connection with their meetings, hospitality, events, and travel, and happy to be here today with my good friend, Lisa Sommer Devlin.
Hi, everybody. Thanks for joining us. My name is Lisa Sommer Devlin. I'm an attorney based in Phoenix, Arizona, and I have been representing the hotel side of the meeting industry for almost 30 years now. So I represent hotels and resorts regarding convention contract negotiation, attrition, cancellation, and all the things that can possibly go wrong when there is an event contract involved. Barbara and I have been friends and colleagues for many years and love to do these presentations together to give you both sides of the industry. And with that, we get to go to what lawyers always require, and that is the disclaimer. What we're telling you today is not legal advice. It's tips and suggestions based on our legal expertise in this area. But your situation that you're having with your particular issue is very dependent on the specific facts and circumstances and the law that would be applied from state to state. So if you have specific questions, you should always contact your own lawyer to get specific legal advice. Sean?
Awesome. Now that we have the disclaimer out of the way, we're going to start off with launching a poll question just to get a temperature check for all the folks that are returning to live events or have already returned to live events. If you guys don't mind answering the polls that are appearing on your screen right now, that would be great. And then we will move to the next poll question here before we jump into the content. So moving forward, how are you thinking about any kind of challenges that you're anticipating walking into sourcing as the pandemic fades away? We'd love to know your responses, and we'll make sure that these responses are also shared with the rest of the folks who have attended today's meeting. Given just another second here to get everybody have a second to respond. All right. I'm going to pass it over to Barbara and Lisa to take it away for the first half of our presentation, looking at moving forward with meeting and events in a post-COVID world, how planners should be thinking about it. Barbara, Lisa?
Thanks, Sean. So focus today on the going forward, the path forward. I know many of you have already jumped into live events, or some of you are intending to do so later this year. So really focus on some of the things that I'm seeing across my desk, as well as obviously what Lisa's seeing across her desk as well. Often the concern that planners raise with me in going back to live events is health and safety issues. As all of you know, the health and safety protocols continue to be a bit of a bouncing ball, state to state, locality to locality. And so, certainly we'll talk a lot about this today, but obviously checking as to what's current at the time of your meeting is going to be important. Certainly, we're seeing a return to folks feeling comfortable to travel or also to gather. And that said, a lot of organizations seeking to discuss vaccine policies for meetings and all the rest. And again, we can focus on that as well. And that flexibility is really the key. So many planners will ask, what should I do new in my contracting process? And my main answer to them is build in flexibility to your contracts. None of us know what the path forward looks like. We know what we might want it to look like, but we need to build in flexibility. And we'll talk a little bit more about that as well. But I think going forward, it isn't so much of throwing out your contracts or rewriting every provision. In fact, in a lot of cases, that's the worst thing that you could do, but rather really thinking from a business practical standpoint, what things you can do as an organization to plan for the flexibility, throw out the same old, and really reevaluate your process and meetings top to bottom. Lisa?
Thanks, Barbara. Of course, I agree with Barbara on all of that. As I said, I've been working in this industry representing hotels for 30 years. So I've been through a number of situations that shook the meeting industry, whether it was the first World Tower or World Trade Center attack, whether it was economic downturns or the Great Recession or 9/11. There have been lots of things that have happened where suddenly the market was turned upside down and everybody was scrambling to figure out what they were going to do going forward. And what I want to emphasize is anytime there's a disruption like this in the marketplace, and it's probably best compared to the post 9/11 era when people were concerned about travel, is be fair and don't take advantage. I'm seeing clauses come across my desk where the customer is saying things like, I just had this yesterday, they wanted 50% attrition allowance, and then they were only going to pay for 75% of the rooms below that 50% level. That's really kind of taking advantage. You have to understand that hotels have to have real commitments. They have to know what the financial package is going to represent for the event. So like Barbara, instead of taking advantage and setting unreasonably low levels of things like that, it's better to say things like, we're going to poll our potential attendees to get a pretty good temperature on how many people are going to be willing to attend the event. Then we're going to build in review dates in the contract where both parties sit down and evaluate what the need is going to be for the event and make adjustments as necessary. It's a lot easier for a hotel's perspective to say, we're going to look at this 6 months out, and at that point mutually agree to reduce your block by a specific amount, than to have an attrition clause that the group or the hotel has to hold the block right up to the event date and then only gets to be paid if less than 50% picks up. So it's working together in advance, adjusting things as necessary so that both parties have an opportunity to adjust their business to compensate for what's going on. Barbara?
I couldn't agree with you more, Lisa. I think both parties, the groups and obviously the hotel community, we have a lot of ground to make up. We have a lot of ground to make up as it relates to revenue in particular. It's not all going to be gained at once. And I think to your point, Lisa, there's that balance of the business relationship. And look, these business relationship and our industry's importance on relationships, certainly that shows true as continued with the pandemic and obviously throughout the pandemic. Going forward, that will continue as well. But again, not all ground needs to be gained in the first iteration of a contract. And the discussion there, the flexibility, those are the types of clauses that I look for that I think serve both the hotel and the client well.
It's always a good idea when you're talking about these things is to try and look at it from the perspective of the other side. So if you're the group, say, well, from the hotel's business perspective, when do they need to know that we're not going to achieve our minimums, and how can I help them with that? From the hotel side, they need to understand that the groups are worried, they're concerned, they're not sure what they're going to be able to achieve. And so again, that flexibility and review dates farther out is better than just negotiating clauses that aren't necessarily fair to both sides.
Awesome. Let's go to the next slide. How best to approach contract commitments.
Well, as I mentioned earlier, the force majeure clause certainly has been the focus. And as Lisa mentioned as well, those of us in the business in 9/11, 2001 know that that's, force majeure clauses, which probably were always sleepers in contracts, came to light. And certainly they've come to light with regard to the pandemic. Just a couple points here. There's generally no need to change the force majeure clause that you're using, as long as you have the basics of the grocery list of the bad things that could happen and that catch-all statement, such as any other cause beyond the party's control. But really, it's that trigger point we talk about so often, that a force majeure event has to render a contract, party's ability to perform the contract commercially impracticable, illegal, impossible. That obviously is where all the focus is. So, don't try to clutter your force majeure clause with a lot of stuff specific to COVID. You really don't need it, likely. Again, talk to your legal eagle about that. Not all problems are solved by through the force majeure clause. In fact, one strategy, or among many strategies that could be considered, is looking at cancellation fee schedules. Looking, in other words, at putting your business in the position that it could make a decision about having a meeting, even if it wasn't well-founded in the force majeure clause, it could pay a cancellation fee that it could live with. Similarly, we see changes to deposit schedules that are also factored in on whether the meeting is going to go forward. So I definitely would say that on the force majeure side. Lisa, I know you're seeing as well lots of folks wanting to change force majeure or to be specific with regard to COVID. And I think you agree there's really no need to change the clause if it has the basics.
I certainly agree. And I hope everybody's hearing Barbara and I both say, you don't need huge force majeure clauses. You don't need huge COVID clauses. Remember, a year ago, nobody had ever heard of any of this, and yet the industry shut down and everybody was excused from their contracts. It's like what the Supreme Court said about pornography. It's difficult to define, but I know it when I see it. I think the only thing that needs to be changed in your clauses is timeframes, because traditionally force majeure clauses would say, you have to notify us within 10 days after the force majeure event, or your rights are waived. Well, we've never had what I would call a rolling force majeure before, something that has gone on for months or potentially years. Usually it's 9/11, it happens on 9/11, or Hurricane Katrina, when it's there. This has been different. So the only change I'm really making in force majeure clauses is putting in timeframes relative to government restrictions, because people were unable to have meetings back in October, but now they are. And so it wouldn't be appropriate to cancel last October for a meeting for this September, because while it didn't appear possible back then, we now know that it would be. And so I'm trying to shrink those timeframes to a point where the parties make a reasonable no-go decision. Other than that, I don't include anything about COVID. I don't include pandemic or epidemic. I know there's people out there advocating that, but we're still in the middle of an epidemic. It's going to continue for a long time. While we're getting better in the United States, it's continuing around the world. And so putting epidemic in means that you've already got a situation covered by your clause the day that you sign your contract. That's not helping you. So I think Barbara and I agree on this. You don't need to add a bunch of language. I do consider timeframes for when that cancellation window occurs, but other than that, I wouldn't do anything different.
Yeah, Lisa, and I think the timeframes that you mentioned is a reasonable approach. As you well know, we've got clients with small meetings and clients with citywide conventions. So I think that timeframe has to be flexible, and obviously the parties will negotiate it. But I do think it is a good workaround strategy if the parties are at odds as to the force majeure clause. On attrition,
go ahead, Barbara.
I was just going to say, you often mentioned a few minutes ago, Lisa, an example about an attrition clause and what the client was seeking. Here again, there's lots of focus on attrition clauses and what needs to be changed. And I go back to saying, if you've got the good, the nuts and bolts in the provision, you're in good shape, but many groups don't. So really focusing on that room block attrition clause, the formula that you're building is going to be particularly important, especially if the parties agree to revise the room block. Does that attrition clause come along with it? Does it sync up with the revised block? That's always a main issue. Another thing certainly I'm seeing more of is attrition based on nightly pickup as opposed to cumulative pickup. So cumulative, we add up the highs, subtract the lows, the net number. Nightly, obviously, we just look at the nights that the group was short on. So be very careful about that. And many hotels are offering no attrition, which is super, but you got to put it in the contract, because if you don't put in the contract, as you know, Lisa, the hotel could assert 100% of the block was guaranteed by the group, and that's obviously a concern.
And I agree with Barbara on that. So let's be clear on that. If your contract says nothing about attrition, it means you are responsible for 100% of the block. If your contract says you are not responsible if you don't pick up guest rooms, that's what they call a no attrition clause, and that could protect you. However, it's important to understand that if you have a clause that says you don't owe anything, if you don't pick up your room block, your contract may not be enforceable at all, and the hotel could cancel you if it gets a better opportunity. If you have no minimum commitment under that contract, then there may not be an enforceable contract at all. And we could go into the legal arguments about that, but it's something to be wary of. And that's another issue that I've seen every time we've had a disruption in the industry. Groups get into contracts that everything is on their side. And then once things start to pick up, the hotel gets better opportunities and they're canceling bad deals that they made when business was bad. You don't want to be in the position where you've made such a good deal for yourself that the hotel decides that they could do better without you and cancels. And putting in a clause that says the hotel cannot cancel is not going to protect you. That's not going to be enforceable. So have a reasonable attrition clause, and as I've been suggesting, have review dates so that the parties can work together to realistically manage that block. Barbara, what about that F&B minimums? What are you doing there?
Yeah, so food and beverage minimums, certainly with adjusting a room block often comes adjusting a food and beverage minimum. But one strategy I've seen now and recommended for certain groups is to consider, similar to room block attrition, allowing for some slippage on that minimum, allowing for some adjustments to that minimum. We don't often think about it. Often at the time the parties enter into a contract, they pick an amount, a plus amount before tax and service charge that they feel comfortable that they'll generate. My point to clients, again, on the flexibility theme, look to see, I have clients that we've negotiated a sliding scale for food and beverage minimum based on the number of attendees. Others have agreed on a certain ability to reduce that number by 1%, et cetera. So those are all really good strategies to have, I think, when it comes to the food and beverage. And just remember, as I just said a moment ago, these food and beverage minimums and contracts are typically stated as top of the bill, plus, does not include service charge, does not include tax. We have seen with relating to COVID, higher service charges, higher food costs because of the different way in which food is being provided for meetings at the moment. And so some groups, wrongly think that's going to be captured in that number, and it may not. So read that really carefully. Lisa, I know from the hotel's perspective, there's always, there are various requirements surrounding surcharges, service charges, and the like for food and beverage.
Well, the thing about food and beverages, always remember, you should never use plus in your contract. Or if you do, you have to define it, because while all of us on this call probably understands that plus means the price plus gratuity, plus service charge and tax, a court wouldn't understand that. So you need to have your terms defined in your contract as to what that plus means, because you may not be able to enforce that otherwise. But I agree with you, Barbara. There's a lot of things changing in the industry with regard to food and beverage. There's a lot more dietary issues where multiple menus have to be provided for different people attending the event. There's also different service standards. A lot of buffets have gone away, although that may be coming back now that they're reevaluating the science. So those are things, again, in partnership, you should be sitting down with the hotel and saying, how can we do this? How can we make this work? And be realistic in your food and beverage. If your budget is X, you've got to get that on the table right away, because the hotel is evaluating your business based on the total revenue package, the food and the rooms. So saying that you're not willing to make a food and beverage commitment is going to get you different room rates and different concessions. So keep that in mind.
And Lisa, finally, we hear a lot to talk around the hybrid events. Certainly, I have clients that have discussed that. Often the situation with a hybrid event is that the cost is just too much for the organization to bear, but it is something groups are looking at. And sometimes it's not a hybrid of the whole meeting, but rather certain portions of the meeting. That said, hotels and convention centers took the opportunity during COVID to upgrade their systems, to upgrade broadband. Some have put in studios, understanding that some of the future will revolve around that type of broadcasting during a meeting. So ask for things surrounding broadband, surrounding upgrades, surrounding sharing costs with hotels, if that's something that your group's doing. We're seeing a lot of hotels offering that up to groups. Again, there's an incentive to sort of come back on the water, and that these are ways that you can look to still have your event and again, be able to broadcast, not with an astronomical cost. And this goes back, Lisa, to the negotiation adage, which is, if you don't ask, you don't get.
And that's very true. But hotels are being very creative in this arena. I think that we all agree that things are never going to quite go back to the way they used to be. I think there's probably always going to be some hybrid element for meetings going forward, because there's just logistically reasons that people are going to now say, you know what, I don't want to take the time and money to go to this event, although I'm interested in the content. And so I think that you need to talk with your hotel partners about what they can offer you in the hybrid arena. I know that there's one chain that is offering options where you can have a series of satellite meetings. You can have 15 people in Des Moines and 10 people in Minneapolis and 40 people in Chicago or something. And they're local, but then there's also a hybrid component, and they're offering deals on those kinds of things. So as Barbara says, if you don't ask, you don't get. So ask, see what's out there. You may be surprised at what opportunities you'll have.
Excellent. One of the projects that Barbara and Lisa have partnered with HopSkip on over the past year or so is a new feature that we've built on our platform, which we call the Contract Clause Education Center. This is a feature inside of HopSkip that allows planners and hoteliers to get familiar with the most common contract clauses and provisions that they should expect to see in their hotel agreements. So we wanted to make sure that you guys were aware that this is available in HopSkip with the hard work of Lisa and Barbara, and we wanted to share it with you guys. So we're going to put a poll on the screen right now, and if anybody's interested in finding out more about this new feature on HopSkip, we'd love to show it to you and provide you an overview. So if you could please respond with either a yes, please, or a no, thanks now, that would be great. And we'll keep the presentation moving. I'll just give everyone 1 or 2 more seconds here to respond. And I think we're good. All right, the next slide, which we obviously just posted this poll, is around feedback that actually came from everybody on these webinars. So we've heard over the past, I guess almost 1.5 years now that we've been working with Barbara and Lisa and presenting these webinars to folks, of all the great feedback. And really these webinars have been such a success because of your feedback. So what we wanted to do is take it one step further, and we've now built a YouTube channel that has a lot of the information that's been discussed in past webinars, as well as today's webinar, in bite-sized videos on the HopSkip Meeting and Event Sourcing Insights YouTube channel. So we're going to share the link to subscribe to that channel in the Zoom chat, but we'd love to have you as a subscriber. These are all obviously free for you to consume, and hopefully provides a lot of value. Okay. Now we're going to switch over to the Q&A section of today's webinar. I'm going to kick it off with asking Barbara and Lisa the following question. So what are the legalities around asking for proof of vaccination and or test to enter an event? I know this varies somewhat by state, but regardless of destination, can a corporate entity state that no matter where we go, my employees need to provide this documentation to attend the event? This is a company policy, not the destination policy.
So I'll jump in and let Barbara follow up, because Barbara actually has more detailed expertise on this. But as Barbara said, this is a bouncing ball. And the ball is bouncing really fast. It varies from state to state and location to location, and it depends on the particulars of their regulations. We just heard today that a cruise ship had people test positive on the cruise ship, and now Florida is going to be supposedly passing a law that cruise ships can't require vaccines or testing. It's going to be all over the board. From a corporate position, I think a corporation could adopt a policy that they require vaccines, but you're opening yourself up to problems because there are those people who can't get a vaccine for various reasons or won't because of specific beliefs that they may hold. And you may find yourself in a position where people are making claims saying that they're being discriminated against. With regard to the state-by-state regulations, Barbara and I aren't here to tell you to hire a lawyer, but I think that that is one area where you are going to need some legal help, because it depends on the specific jurisdiction as to who's responsible and how are they responsible for making that verification. In some cases, it's the venue that's holding the event that is responsible for determining vaccination status. In other cases, it's the event sponsor. Maybe both can be held responsible. So it's a very tricky area, and it's going to continue to be very tricky as we roll forward. There was another news report today about a new potential side effect that's going to cause more people to be hesitant. So it's going to be a difficult situation, and it's something that I think you really need to examine right as you're getting up to your event, because it changes so fast. Barbara, what do you think?
Lisa, I agree with everything that you said, and just to pick up on some of the items. First of all, as you noted, the bouncing balls of the state and local regulations continue to change as we speak. Yesterday, I looked at a contract for a client in a meeting in California, and California has a requirement that it's the event organizer's responsibility to make sure either everyone attending has been vaccinated or can produce a negative COVID test. And so that's become a state laws in a lot of places. Again, always check on that. But in terms of what a business can do, for profit, not for profit, in terms of their meetings, we saw organizations step up. For example, HIMSS, the large healthcare trade show just a few weeks back, mandate vaccines for their meetings. And we've seen others that follow. So as you indicated, Lisa, you can mandate vaccines to attend a meeting. The only two exceptions you must offer would be, again, a health circumstance preventing someone from getting the vaccine, or a sincerely held religious belief. Absent that, there are no other exceptions that you have to offer. But as you point out, Lisa, the business issues are there. For some organizations, they don't want to go there, quote unquote, and require them. But I have a fair amount of clients that are and do. And the best thing is, if you're going to do that for your meeting, please use a third-party vendor to keep and store the information. The World of Concrete show just wrapped up in Las Vegas, and an example of using a third-party vendor to capture and retain vaccine information. And the reason I say that is you don't want to touch it because it's health data and it's protected. You want the company who is secured, hopefully in their data protection, hire them to keep and store the data. But a lot of other organizations are using the honor system. You know, everybody coming to the event says they're vaccinated and they're not requiring proof. And so there are pros and cons there. And then of course I make the point to clients is, you know, it's not just the other folks attending the meeting, it's everyone working at the venue. Your AV provider, your decorator, your venue partner, et cetera, the list goes on. So just be careful of, don't make big sweeping guarantees. I'm often reviewing safety and health protocols. Don't say this is going to be a safe environment. Don't say that it's going to be COVID free, right? Just stay away from the absolute statements. Have a good placeholder statement that essentially says, we understand the issues, we're monitoring them, and as we get closer, we'll let you know. I think those are probably the best ways to address the strategy. I saw, Lisa, in the comment, a question about the emergency use authorization of the vaccines, and the question as to whether that could be mandated. And I know we've talked about this a little bit offline, and there are some groups out there that are pursuing employers, some are pursuing universities that are requiring the vaccines. It'll be interesting to see to the extent that that can be successful. I think the points made against it, though, is it appears that we will be likely getting the final approval, that is pulling away the EUA on some of these vaccines. And beyond that, the scientists say, look, they did everything they would normally do to get the EUA authorization on the vaccines as they would when it comes to the final process. So it'll be interesting to see, but don't pick a fight with your attendees if you don't have to. One last point I'll make here, a lot of clients are surveying their membership. Perhaps those are folks who might have attended their meeting in 2019 and asking whether they're fully vaccinated and giving that definition that we know of as fully vaccinated. And, you know, in an anonymous way to the extent that can be. And the reason they're doing that is if they know that they have a high percentage of folks who would normally come that are vaccinated, that they might not even need to require that. But it is something to think about. And again, still, Lisa, we're going to have these on-site protocols, which will continue likely, whether it be face covering, social distancing, et cetera. So I think organizations should be mindful of that as well as they're setting up their meetings.
Yeah, and I would just add to what Barbara said, on top of the health issues, you've got the political issues that are involved in a lot of this. And so it can create all kinds of headaches for you as an event sponsor. So that's why it's so important to understand what the legal requirements are and be mindful of those exceptions that Barbara talked about so that you're not getting yourself into an issue with your attendees. And I agree with Barbara as well. Excuse me, that surveying your people and getting information from them about how they're feeling can be very helpful in making these planning decisions.
Excellent. And I should also mention to everyone in the audience, feel free to send questions in the Q&A chat, because if we don't address it live, like I mentioned in previous webinars, those questions help us form topics for future webinars. So we welcome all questions. The questions that we're going over right now are any question that we've received in advance of today's webinar. The next question that we have received is, if a state's guidance for events of certain sizes requires proof of vaccinations or proof of a negative test, who is responsible for enforcing this and who would be liable? I know we just touched briefly on some of this in the previous question, but if Barbara, Lisa, if one of you could expand, I think it would be helpful to the folks in the audience.
Sure, Sean. So I was just mentioning in the California law that many of you might be familiar with. In the case of meetings happening at a hotel or a venue, it is the event organizer's responsibility that folks either be fully vaccinated or have a negative COVID test. And that's a lot of responsibility on the event organizer. So going back to whether you're going to require vaccines or not, you're taking on that risk. Other circumstances, restaurants, et cetera, that may be the restaurant's responsibility to do that. But it is the question of enforcement is particularly sensitive as to what, you know, how do I know? How do I prove it? I don't want to keep the data, right? So you take on this responsibility. So, you know, comment here is don't take on a responsibility that you can't manage. There may be a state minimum that it needs to be done. And then you might have a venue that wants to push even more responsibility over on the event organizer, such as indemnification, which goes outside the scope of what the state might require. Again, you've got to look at every level. City, county, state is important. One other comment on the vaccines is that those of you who are working with companies based internationally or organizations which have international membership, keep in mind that our definition in the US of fully vaccinated, citing the 2 vaccines that have approval, in other parts of the world, those aren't the 2 vaccines, and their definition of fully vaccinated might change. And the question becomes, where are you going to host the event? And so the consideration needs to be given to whether you will extend recognition of those other vaccines as it relates to fully vaccinated. And I think that's an ongoing issue as well. And Lisa, I know you've got a lot of hotels, you know, inside the US or otherwise trying to manage these state laws. I don't know if you have any firsthand experience as well of
well, I do, and that's why I said I don't like to recommend people hire lawyers for everything, but I think that this is an arena where you should, because I've had one experience where new regulations came out And I spent a half an hour on the phone or on a meeting like this with my hotel partner, going through the new regulations line by line, because it was sort of a tiered system depending on the size of the event, depending on the nature of the event. The protocols were different and who was responsible was different. And it's very, very complicated. And so to make sure that you're doing it right, you really need to get someone to help you unravel all that legalese that are in these regulations that are coming out. And again, they're very state specific. I just learned recently that Hawaii will not accept vaccinations from any place other than vaccinations issued in Hawaii. Otherwise, you have to get tested even if you have a full vaccination card. So you have to be very specific as to where you're going and what the requirements are. And I really think it's a good idea to get some legal help on that, so that you are making sure that you're crossing all your T's and dotting all your I's. Because if you don't do that, and something goes wrong and somebody gets sick, you're opening yourself up to have a claim filed against you.
Exactly. Well done, Barbara and Lisa. Let's hit our next question. When contracting for future years, not knowing what we as an industry or society will be facing, what are some suggested contractual terms to allow more flexibility with attrition and cancellation?
Well, as I've said, I think building in review dates into your contract, the farther out that you're contracting, build in review dates and say, we're going to evaluate after this year's meeting, we're going to evaluate a year out, we're going to evaluate 6 months out. That way, if you need to make adjustments, the hotel that you're working with has time to perhaps resell the inventory that you're releasing. If you get all the way to your event dates and suddenly you're coming up short, it's too late for those losses to be made up. So I'm a big proponent of review dates and being fair and being reasonable in the amounts in those clauses. Barbara?
And Lisa, I was just going to ask, because I know this has come up in the Q&A during today's webinar, and Barbara, you might be able to chime in on this as well. Would you have any recommendations for a timeline of those review dates?
Sean, that depends on the event, the venue, the time of year, too many things to even begin to guess. And you have to be balancing both the group's needs, when are they going to be in a position to evaluate what their needs are, and the hotel's needs, because the hotel may say, if it's a resort in Hawaii, rooms released less than 6 months out really do them no good, because they just don't have the opportunity to resell those. If it's in New York City, they may be able to resell those rooms 4 times. And so it depends on so many factors that you need to really think about that. Barbara?
Yeah, absolutely agree on that point. Some nonprofit associations won't even know inside 30 days what the numbers look like. And I expect that range is even going to shrink more. And yet some corporate business may know 60 days out what that's going to be. Bottom line, be specific about the timing. Often I see 60 days, but it doesn't say from what. Is it the day of check-in, et cetera? I know these may seem minor issues, but these are the kinds of things that cross Lisa's desk, my desk as well. So be mindful of those. Be mindful of whether the attrition fee will go along with any revisions to the block. Similarly, with regard to cancellation, again, to the extent the parties are negotiating a cancellation fee schedule, pay attention to the date side of the column. Make sure that you can live with the dates, negotiate those dates. Again, allow yourself to make a business decision if you can't have this meeting. I think all of those are really good strategies. I think one last comment I mentioned briefly earlier, really look at your organization's timeline for doing things. For example, just because you always open registration 6 months out doesn't mean you have to do it. And many of you learned last year that was on the fly. So really looking forward. But to Lisa's point, I think it's particularly important. It depends on the type of property. The good news is folks are traveling generally for leisure business. So if hotels have rooms back in certain areas, they can sell them, and that could benefit both parties. In other circumstances, they may not sell them as quickly. So be mindful of that as well. But I think each of these are strategies. You can't fix everything in the contract. You also have to manage it practically. And I think these are some strategies that I've seen work.
And Barbara and I have mentioned in other videos and webinars that let's emphasize again, when you have a liquidated damage clause, under the law of liquidated damages, resale or mitigation is not required. That doesn't mean you can't negotiate it and get it, but it's not mandatory. And so if you do that and you have resale, you need to clearly define how that resale is going to be credited. And when Barbara talked about 60 days out, I'm a big proponent of calendar dates, June 1st, not 60 days or 90 days. We all know when June 1st is, but 60 days depends on how you count it from a lot of other things. So use calendar dates. And then when you make those adjustments, as Barbara said, the adjustment needs to say, now that we've released rooms, how does that impact our cancellation? How does that impact our attrition? Is there resale credit? And if there is, how will it be calculated? So that all of that is documented every time you make those changes.
I agree with you, Lisa, on the exact dates. And I would even go one step farther and identify the time zone. That can be a big issue, as you know, if we're talking about Hawaii. So just another thing to think about as well. Sean?
Excellent point. Excellent point. I wonder how often the time zone is not thought of. All right.
Really?
Next question. With COVID-19 restrictions being different in most countries, should I change any of the protocols we have in place if we are hosting international attendees for our upcoming face-to-face meeting?
So this question seems to imply that the meeting would be held in the US with international attendees. So as I mentioned earlier, make sure the organization has considered folks that might have a different vaccine coming to the US than what we have. You got to start with the basics of the federal travel restrictions and regulations, and then work your way down to what you want to have at your meeting. But you definitely need to consider that. Consider whether you would require folks, and this is another hot issue, would you require folks that are unvaccinated or folks, international attendees, let's say we don't recognize that vaccine, to wear face coverings, to social distance. There's a lot of discussion around that. Now, of course, states now are lifting face coverings in large part, yet organizations would still like to have those as a best practice. So there's a lot of this shaming, or however you want to say it, that may come along with whether it's an international attendee that might not, be able to check our box as to the vaccines in the US, or someone who chooses to be unvaccinated or maybe has to be unvaccinated and wearing face coverings. And I do have a number of clients that have gone ahead and has gone to sort of the most strict continued safety and health protocols just because of that reason. That is, everyone would wear that. Similarly, we've had the opposite there too. So it's really something difficult. To me, as Lisa mentioned earlier, it's a small p political issue, likely more than a legal issue. But international folks, you definitely want to consider. And of course, if your meeting is outside the US, obviously you have to look at the local regulations as well. Lisa?
Yeah, so, and something else to think about is if your meeting is highly dependent on international attendees, that's something you may want to address as part of the contracting process. I was having a negotiation this week where the customer was explaining how heavily dependent on international attendees they were and their concerns about that. And instead of just having a cancellation if international attendees can't come provision, what we worked out is if X percentage of the attendees who are supposed to come from international locations can't come, and they can demonstrate that, then we'll waive the attrition as to those attendees, but the event will still go forward. There are a lot of creative things you can do if you talk about what your needs are, your budgetary issues, those kinds of things, and then craft clauses around that to create a win-win rather than just having these very draconian clauses that say, oh, if this happens, we're canceling and not paying anybody. So work around that with your international attendees and build something in to address them as a specific component of your event.
Yeah, Lisa, just one other, I think it's a great suggestion. And I completely agree with you. One other thing to think about, we are seeing organizations, facilities, and otherwise talk about in a force majeure setting or in the international attendee setting, the example that you gave, that the group would need to consider making changes to its meeting in order to fit at the hotel or work at the hotel or whatever the case may be. It's all about what the parties negotiate. So if you agree to a clause that says that, then you've got to understand what those parameters are. But many of you experienced the fact that a hotel might have been able to host your meeting, but for the local capacity restrictions. And so many hotels offered up alternatives of additional meeting rooms, splitting the group, et cetera. And again, whether that was required for a group to consider or accept, now a lot of that is being baked into the hotel contract, which makes sense in some respects, but from the group side, it's something to be very mindful of. That's something that we're seeing, but agree with you that when I talk to clients about negotiations and how to approach the other side, my approach is to say that you want to share what the concern is, rather than my clause versus your clause. You see a group with a one-page construction clause, that group's been burned before. Rather than putting it in at the outset, say, look, we've been burned before. This is what we're seeking in a construction clause. And as you suggested, Lisa, have the parties build it together. I think that's a really good approach to take. And there are some provisions that a lawyer should look at, specifically indemnification is one of those. But in other cases, I think the parties can work very well together. But again, you've got to communicate the concerns that you have so that you can best address them.
And just to emphasize that, when you're negotiating a contract clause, it's always important to ask two questions. What are you concerned about, and what do you want to have happen? And if you get the answers to those two questions, you can build a clause that works for both sides. And that's really important to do.
I love that. That's a great tip, Lisa. I feel like that's not spoken enough. The next question, what are the positive or negatives around requesting an escrow account, and why might hotels not want to do this? Lisa, do you want to take this one first?
Sure, I'll take this one. So I'm sure people realize this. What typically happens when you submit a deposit for an event that's not going to take place for a year or two or whatever, the hotel doesn't take that deposit and put it in a special account and hold it for you. They put that on their books as income, and it's part of their cash flow. And what happened last year, as meetings were canceling, customers would say, I'm canceling my meeting, I want my deposit back. And the hotel would say, yep, you can't have your meeting, and we agree you're entitled to your deposit back, but we're closed and we don't have any cash flow. And so we don't have that money to give back to you. And people had to wait a long time to get their money. It was frustrating for everybody. And so some groups have said, I don't want that to happen again. I want you to take my deposit and put it in an escrow account and hold it aside so that if something goes wrong, I know I will get that money back immediately, and also put it in that separate account so that if we have disputes over the bill, there's a third party holding the money, and until we can work it out, we know that that money is safe. Hotels are going to resist that for a couple of reasons. A, the basic cash flow that I explained, they want to be able to use that money. And the other reason is that if you're doing an escrow, it has to be formally done. You have to have an escrow agreement that sets out how the money will be held, where it will be held, when it will be paid out, all those kinds of circumstances. And you have to have a separate account created that somebody has to go out and get and somebody has to manage. And there's legal implications for all that. Hotels are going to be very resistant to that for all of those reasons. There's a couple of escrow companies out there that address the meeting industry, and sometimes it is used, but I will tell you that from the hotel perspective, it's not something that they're going to welcome when you're asking for that kind of thing. Barbara, what are your clients doing?
Yeah, absolutely. Lisa, I recommend self-help. Self-help in negotiating the deposit schedule. Consider having more deposits, lower amounts of deposits, scaling up to the event date. If you're concerned about your money sitting at a place, I think that's the best strategy that I've seen. That way you're not worried about an entanglement with your money. You won't be there. You haven't paid it yet, right? So I think that's probably the best approach that I've suggested. I agree. For lots of all the reasons that you'd mentioned from the group's perspective as well, it's not reasonable to seek the escrow. You're better off negotiating the deposit schedule.
Excellent. I appreciate that. That was great answers. I know that this is something that's been on planners and hoteliers' minds for a while now over the course of the pandemic. And that actually brings us to our last slide. It's a big thank you to Barbara and Lisa for another wonderful webinar. I hope this was super informative to everyone who attended today. And a big thank you to everyone who attended, because like I said earlier, your feedback is so important and it's what makes these webinars valuable. So as a thank you, HopSkip is currently offering planners and hotels who attended today's webinar 6 months free when purchasing a pro subscription before the end of this month. So if you'd like to learn a little bit more about HopSkip and how it can streamline your meeting and event sourcing process, we're going to display a link on the screen now. And please click yes, please, if you'd like to get a demo with HopSkip. We'd love to see you. And thanks again, everyone. We look forward to the next time. Take care.
Bye, everybody.